Hello everyone, welcome back again to my channel. Before watching this video, don't forget to like, comment and subscribe. Now let's start this video. History of Admiralty and Maritime Law. Maritime law, also referred to as Admiralty law, is nearly as old as the shipping industry itself and governs most accidents that occur on navigable waters. The law roots can be traced back to unwritten custom of nautical behavior of the Egyptian and Greeks. However, the earliest formal codes were established around 900 BC on the Greek island of Rhodes. The original maritime laws and codes stem from the ancient custom and rules of shipping. For example, the doctrine of general average, the concept that all sea cargo stakeholders, owner, shipper, and etc., evenly share any damage or losses that may occur as a result of voluntary sacrifice of part of the vessels or cargo to save the whole, can be traced back to the early shipping custom of the Rhodians. The concept of a separate legal authority regulating maritime issues was brought to the West by Eleanor of Aquitaine, who learned the concept when she accompanied her first husband, King Louis VII of France, to the Mediterranean of the Second Crusade. The term Admiralty law came from the British Admiralty courts, who presided over maritime matters separately from England's common law courts. As the U.S. judicial system is based on the British system, amended Admiralty laws were gradually incorporated into our legal system soon after the Constitution was ratified. Perhaps most obviously, maritime law applies to events that occur on high seas, in other words, accidents that happen beyond the territorial waters of any country. Furthermore, maritime law applies to the territorial sea, which are waters within 12 miles of the shore. However, the law's applicability becomes less clear further inland. Early in the United States history, maritime law didn't apply to incidents that occur within the body of the country and therefore exclude incidents involving the Great Lakes and non-tidal inland waterways. However, throughout the 19th century, this exclusion eroded away. Maritime law is now applied to navigable waters. A waterway is deemed navigable if by itself or by uniting with other waters. It can serve as a continuous highway over which commerce is or may be carried on with other states or foreign countries. Consequently, if a body of water is completely landlocked within a single state, then it is not navigable for purposes of Admiralty jurisdiction. However, a body of water doesn't need to flow between states to be deemed navigable. A body of water may be deemed navigable if it's a link in a chain of bodies of water that can be used to service interstate commerce. Ultimately, the test is that the commerce of one state must be capable of being carried into another state or a foreign country. Once this test has been passed, it is likely that maritime law will be applicable even if it is a recreational vessel. Houston maritime injury attorneys exist to help injured seamen or dock workers get the compensation they need to recover from serious injuries and afford long-term medical costs that occur offshore. That includes any accident that occur on navigable waters, rivers and oceans, and in harbors or docks. One notable aspect of maritime accidents is that they are often devastating. Offshore oil rig explosion causes significant damage, vessel collisions are frequently catastrophic, and oil platforms can unfairly change the lives of workers. Maritime lawyers fight to help workers recover the compensation they deserve, whether they are suffering after a major explosion or have injuries caused by unsafe working conditions. Maritime law is derived from many sources, federal statutes and general maritime law being two of the most prominent. These sources provide some of the maritime doctrines that are commonly used in cases involving vessels and their passage and crew. Maritime law sets forth many of the basic legal tenets associated with the sea and seamen, including seamen right to maintain and cure. Maintain and cure are benefits that an injured seaman receive from an employer during the course of recovery. Maintenance includes such expense as the seaman's rent or mortgage, utilities, property tax, homeowners insurance, and food. Cure is similar to workers' compensation benefits for land-based employees. It covers costs related to medical treatment for the work-related injury. A seaman is someone who is a captain or crew member aboard a vessel in navigation, also similar to workers' compensation. Maintenance and cure does not require that the seaman prove any fault for their injury. The employer is required to pay. The Jones Act. The Jones Act is a federal law that gives seamen a statutory right to sue their employer for personal injury damage. However, a seaman must spend at least 30% of their time working on a vessel to qualify for the Jones Act. Not only does the Jones Act provide the seamen a statutory right to sue their employer, it also eases the burden of proof needed to prove causation between the employer's negligence and the seaman's injury. Under the Jones Act, the employer's negligence only needs to play a part in the seaman's injury rather than being a proximate cause. The Jones Act also incorporates aspects of the Federal Employment Liability Act. In particular, claims filed in state court under the Jones Act are not removable to federal court. The Death of the High Seas Act. When the death of an individual is caused by a wrongful act or neglect occurring on the high seas, the Death on High Seas Act guarantees that a personal representative of the decedent can bring a claim. The Saving to Suitor Clause. Federal law establishes exclusive jurisdiction for Admiralty and Maritime cases in the federal district courts, absent any language indicating the contrary within a statutorily created right such as the Jones Act. However, the Saving to Suitors Clause reserves any non-admiralty remedies that may be available to an individual. An example of an admiralty remedy is a suit in which the claim is brought against the ship. Longshore and Harbor Workers Compensation Act. Federal law created certain statutory rights for employees who are not necessarily seamen but nonetheless work on harbors or vessels that are under repair or being built. This law covers longshore workship, repairs, shipbuilders or shipbreakers, and harbor construction workers. Moreover, the injuries must occur on navigable waters or an adjoining area such as dock. This law provides for the payment of compensation and medical care for an individual injured while in the job or survivor benefits. The Outer Continental Shelf Land Act extends the Longshore and Harbor Workers Compensation Act to employees engaged in offshore drilling on the Outer Continental Shelf. Today, maritime law consists of laws that are derived from legislative enactments, judicial decisions, and international treaties. Those who are affected by maritime law include crew members of vessels, longshore and shipyard workers, passenger ship owners, cargo owners, marine insurers, and many others. One of the most significant modern maritime statutes is known as the Jones Act, which was adopted in 1920 as a way to protect seamen and vital United States interests and supporting a United States merchant marine fleet. Under the Jones Act, seamen were given the right to sue for injury or death caused by the neglect of their employer. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.